Member from Vancouver Fraserview.
Thank you, Chair. I will confess to being a bit mystified by the answers provided to some of these questions by the Justice Minister. It seems to me that we're all in agreement that if somebody's missing and in danger in some form, the police should have the tools to find them. And yet every time we ask a question about whether there's an unintended consequence to provisions in this Act, such as the use of the word or between A and B in missing person instead of and, when it seems clear to me and to my colleague from Vancouver Point Grey that if you take A on its own, it's virtually a blank check. When we ask questions in this regard, we simply get brought back to the purpose of this Act is. We know what the purpose of the Act is. What we're trying to ask is questions about unintended consequence. And to define a missing person on its own as someone who has not been in contact with those persons who would likely be in contact with the individual is, in fact, granting to the police quite broad powers. And it seems to me, Honourable Chair, that it's simply not good enough for the Justice Minister to say she has complete faith in the activities of the police. We all do, and we also all know that laws need to be precise and specific to protect people's individual rights, and if they're not, they will be subject to abuse. So I would simply repeat the questions that have been asked earlier. Why is there an or instead of an and? And please, Honourable Chair, I'm not much interested in hearing for the umpteenth time what the purpose of the Act is. I'm interested in hearing how the Justice Minister thinks that the wording of the definition of missing person as it's currently stated in the draft legislation in front of us simply cannot be abused, because it seems to me that it's wide open.
Minister.
Chair, there have been two problems hypothetically put forward by the members opposite. One is that the Act may be used to find somebody who doesn't wish to be found, and somehow there's something wrong with that. Well, people, as I mentioned already, may be found already who don't wish to be found, and that's normal police practice to not report that person back. The second proposition put forward is that the police may abuse the Act. Well, Chair, police are expected to conduct themselves properly. We don't expect in an Act that a police officer is going to use an Act which is a civil remedy for a missing person in order to further their criminal investigation on something else altogether.
Member.
Honourable Chair, if the police never abused some of the powers they had or never undertook an investigation in an inappropriate manner, we wouldn't have a police complaints commissioner. And that police complaints commissioner would never be considering complaints against the police. So I would ask through you that the Justice Minister simply apply the logic of her office that bills brought forward to this legislature that grant extraordinary powers should be carefully crafted and should be very focused on their intent. In fact, the exact intent that the Justice Minister has attempted to drum into members of this side of the House. If there is a clear intent, there is no reason for the Act to extend beyond the clear intent. And my second point is, the Justice Minister has said that if somebody doesn't wish to be found, no harm done. The police simply let them go ahead being invisible. That's not the point of the question. Surely the Justice Minister understands that what we are saying and what the Privacy Commissioner has said is extraordinary powers to go deeply into somebody's private information are being granted for the sole purpose of finding somebody who is missing and may be at some sort of risk of harm or may in fact have been harmed. So yes, Harm will in fact be done to people's right to privacy if a loophole that has no purpose for the provisions of an express purpose of this act, that is, to find missing persons, is used, in fact, to reveal their private personal information when no demonstrated real need was there.
Member.
Minister would like a question, Honourable Chair, then my question is simply, please tell us how your theoretical or her theoretical faith in the absolute proper behavior at all times of every single police officer in every instance, which is admirable, but as past experience will often point out, perhaps cannot always be relied upon, how she can guarantee that this definition, as currently put forward, will not ever, ever, Honourable Chair, be subject to abuse.
Minister.
Chair, the information accessed under this act can only be used for the purpose of locating a missing person or in a related criminal investigation, as I described earlier. Chair, police conduct themselves appropriately. If they do not, on the rare occasions when they do not, then there are procedures in place to deal with that. But Chair, there are police standards, there's police training, and police in British Columbia really are of the very highest standard in terms of the way they conduct themselves. A police officer using this legislation is using this legislation to find a missing person.
Member.
Thank you, Chair. Let me try and reframe the question in a simpler format, because the Minister has admitted that there are rare occasions where powers may be abused and that there are remedies in that case. I would put forward that if there is an opportunity to close the door, at least more tightly, to prevent abuses, then we should do it, then, rather than simply rely on remedies after the fact. So let me simply, through you, ask the Minister, what harm will be done by changing the word "or" between A and B in the definition of missing person to "and"? How will that possibly interfere with the purposes of this bill?
Member, it appears that we're currently debating an amendment that's not currently on the floor. So unless that amendment is put forward, I think that we should move to member from Burnaby Deer Lake.
Musical chairs. I'm certainly happy to, at this point, introduce an amendment to Section 1, and specifically, I have several copies here, so you can take. Oh, did I give, oh, you know what? I may have given you the wrong. Is it Section 1? I think I might have given you the wrong one. Yeah, no, that's the wrong one, sorry. You can keep that if you want. I'm going to be getting to it later. Sorry. There it is. I move that Section 1 be amended by deleting subsection A in the definition of missing person, and that would be deleting it out and adding text, and maybe I'll just read it as it would be. Missing person means an individual whose whereabouts are unknown despite reasonable efforts to locate the individual and whose safety and welfare are feared for given subsection A, that the individual is a minor, subsection, sorry, that's a 1, and 2, the individual's physical or mental capabilities, or 3, the circumstances surrounding the individual's absence. So I move that amendment.
Okay. On the amendment?
On the amendment, thank you.
Member from Burnaby-Deer Lake.
I'm moving that amendment because we on this side of the House have repeatedly expressed concerns about the inclusion of subsection A as the section is presently written. We believe, I believe, that it would be an improvement to the bill to make it, to limit the circumstances in which an order could be brought under this act, an order for production of records, to a case where there is safety and welfare concerns. It concerns me greatly, as many of us have said repeatedly, that simply not being in contact with individuals should not be enough to trigger an order that would allow the police to access records. And I also believe, Honourable, through you to the Minister, Honourable Chair, that the fact that it would have the circumstances that safety and welfare are feared for given the circumstances surrounding the individual's absence would include the situation where an individual had not been in contact with people that they were likely to be in contact with that individual. But it makes it imperative that a precondition that you have to have safety and welfare being concerned about. And I think that's the proper use. Every time we talk about a person being missing and we talk about scenarios and what circumstances would there be, every single time we talk about it, we and the Minister, Honourable Chair, we and the Minister have all talked about circumstances where there is a concern for their health and safety. So I think it should be explicit. And the reason that I have, in addition, have said that the individual, rather than we talk about that there's concern for the safety and welfare given the individual's age, I think we should be more specific. I think if you say that individual is a minor, it takes it out of that kind of fuzzy area of what do you mean given that the individual's age? Could they be 23, 24? I think it's more clean if you say that the individual is a minor and the senior that we're concerned about would be covered under subsection 3. So for that reason, I'm moving this amendment. Anybody want to speak to it?
Member from Vancouver Fairview.
Thank you, Honourable Chair. Speaking to the amendment, I think we have stated some of our concerns on this side of the House in the context of being generally supportive, certainly very supportive of the stated purpose of the bill. We want to see it succeed. We want to see the police have the tools they need. We simply want to ensure that we don't have to look at possible misuse of the bill and information gained through the bill after the fact and take available remedies. We just want to be sure that everybody, police included, are clear about what the stated purposes of the bill are as clearly stated in the bill. So my question through you to the Minister is, if you believe that this proposed amendment somehow makes it more difficult for police to get the information they need in a timely way, as quickly as currently stated in the bill, to get the information needed to find a missing person, please explicitly tell us what the problem with the amendment is, how the amendment does not allow the police the tools they need to locate a missing person, or any other reason that she thinks that the amendment is inappropriate.
Not technically, you're supposed to just speak on it. Minister.
Chair, thank you. The original, the section is originally, I'm speaking against the amendment. The section is originally written has the broader capability of finding a person in the specific circumstances which are not described in section B. The two fears that are mentioned by the members opposite are these. One is that someone will be found who doesn't want to be found. I have addressed that, Chair. The second is that police will abuse that. I find that offensive. This section, this act is brought in direct response to the Missing Women's Commission of Inquiry. It is done by carefully considering other acts across the country of a similar nature, and it is here to find missing persons. It's here to look for people who are at risk, Chair, and neither of the counter examples that have been mentioned by the members opposite have any legitimacy. If the person doesn't want to be found, they will say so. That happens now. That will continue to happen. If the act, I don't even like to repeat what the members opposite are saying about possible police abuses. That simply is not something that this act is designed for. This act is designed to give police officers a civil remedy to go out and look for somebody. Chair, I'm speaking in support, or against rather, the amendment in support of the original language.
Member for Vancouver Fairview.
Thank you, Chair. Through you to the Minister, I'm looking at, and I'm mindful of the Minister's clarification about the words "in respect of." So Section 7 says that it allows access to a record set out in Section 9 in respect of a third party if the member has reasonable grounds to believe, et cetera, et cetera. And there's a long list in Section 9 of the types of records that could be accessed. Could be contact information, identification information, telephone and other electronic communications records, including, without limitation, records related to signals from a wireless device that may indicate the location, cellular tel records, text messaging records, internet browsing history records, global positioning system tracking records, photos, videos, basically all kinds of records, and at the end, any prescribed records. So that's very broad. There may be records within internet browsing history or cellular records or text records that pertain or could pertain to a missing person, but there would obviously be a broad array of other records that would normally be considered a person's private information. So my question to the Minister through you is, how does the Minister envision some form of containment or limitation being put around the specificity of the records within any of these categories being released to contain them to the purpose at hand, the location of a missing person, and not simply be a broad brush order granted by a judge, because the bill itself doesn't seem to specify much more than a pretty general limitation. For instance, perhaps the Minister believes that the limitations are implicit in the words "in respect of," or perhaps the Minister foresees some form of guidance or regulation or policy to guide the decisions of a justice in being more focused and honed in on the nature of the records, rather than simply saying, hand over this person's entire internet browsing history, hand over this person's entire travel history through their GPS records, hand over this person's entire cell phone inventory of text messages to everybody, hand over this person's entire history of telephone calls to everybody.
Minister.
Chair, I'll read Section 4 to the member opposite. The Justice may impose any of the following that the Justice considers appropriate: restrictions or limits on access to a record specified in an order under this section, and B, terms and conditions on an order under this section. Justices they do this every day, Chair, and they know that the territory that they're operating in, and they put the limits on things that they need to put limits on, and they're quite used to that. That's their ordinary role in criminal investigations up till now and in civil investigations under this.
Member.
Thank you, Honorable Chair. I appreciate the minister pointing me to a section, but justices generally interpret the law based on what the law states. So again, my question to the Justice Minister is, does she think it is appropriate to leave entire discretion over this to a justice to interpret what appears to me to be some vagueness in the act? Or is there any plan to be more specific in direction, even through perhaps a reference to principles of privacy as contained in other statutes?
Minister.
Chair, I have confidence in the justices of British Columbia.
Member.
Well, with respect to Honorable Chair, to the Minister, does that mean that her answer to my question is that she thinks that the legislation is sufficiently specific and there is no intention whatsoever to provide guidance either in the legislation, in regulation, or in policy to clarify, even with respect to references to the Freedom of Information Protection of Privacy Act and when that act should apply and how it should be read in conjunction with this act if they may appear to be in conflict?
Minister.
Thank you, Chair. Chair, there is sufficient guidance in the Act for the police officer to make their application, for the justice to hear the application, and for the justice to make his or her ruling. It is a question of judgment by the justice. It's what they're trained to do, and it's what they do every day in British Columbia.
Member.
Thank you, Honorable Chair, and I'll confess to you that I find the answer troubling because I too generally have faith in the justice system, but we also have a situation here where we have the potential of conflict between two pieces of legislation, conflict that the minister states she does not believe needs clarification. She has, in fact, by her answers, provided what could be termed extrinsic evidence in some future case where a justice or anyone, a police officer, in seeking a certain scope of information beyond which might be considered reasonable by people who are mindful of the Protection of Privacy Act, that in fact the Minister of Justice has said in this chamber that it is entirely up to the discretion of the justice. No guidance will be provided. The Minister of Justice has no opinion on how this bill should be read vis-a-vis the Protection of Privacy Act, the Freedom of Information and Protection of Privacy Act, and frankly, Honorable Chair, I find that troubling. It's important that when legislation is introduced, discussed, and voted on in this House, that it contain a certain level of guidance, particularly if there may be conflict with other pieces of legislation. And I would hope that the Justice Minister can do the people of British Columbia, as well as the judiciary, a service by providing a bit more guidance than "it's out of my hands, I trust you."
Minister.
A few moments ago, the Act itself contains guidance for the Justice, and I'll point out to the member opposite Section 7 sub 3 sub C, there are reasonable grounds to believe that the record may assist the police force in locating the missing person, and D, there are reasonable grounds to believe that the record is in the possession or under the control of the person. That is very significant guidance, Chair, and rather than attempting to define every situation here, which it would be impossible to do, I am confident that there is sufficient guidance in the Act, and I'm confident that there's sufficient guidance in the Justices of British Columbia.
Member for Vancouver Fairview.
Thank you, Honourable Chair. And I share the concerns that were expressed with respect to emergency disclosure demands by the Privacy Commissioner in a letter to the Minister dated February 14th. And this goes to some of the answers that were provided by the Justice Minister in response to previous questions, that in many cases where we expressed concerns, the Minister answered to us that the request had to go to a justice. The justice would look at the demand and make sure it was reasonable, would look at the scope of the demand and make sure it didn't go further than it needed to do. But in the case of an emergency disclosure demand, none of these controls are particularly present. The bill does require that when a member makes an emergency demand for records, and we understand the need for emergency demands, I don't want to in any way question that. There are times when time is of the essence, and if somebody's life is potentially at stake, then things need to move forward quickly. But it is also true that the emergency demand is not subject to the same or any level of judicial oversight or controls that would be contained in other sections of the Act. So the bill would require that the member file a written report with the officer in charge as soon as practicable, and that the police force report annually on the number of emergency demands that are made by its members. The Privacy Commissioner states, I believe the ability of the state to compel the production of records about its citizens is a significant intrusion on the privacy of those citizens. It is not an action that should be taken lightly, which is the reason why such action is generally associated with some level of oversight by the judiciary. Now, I think we all share that view, just as we understand that there will be times when oversight by the judiciary simply would interfere with the very important purposes of the Act with respect to the safety and security of someone who's missing. The Privacy Commissioner has suggested an amendment that wouldn't in any way interfere with the speed with which an emergency demand for disclosure could take place, but that would provide some greater level of oversight than a simple annual reporting of numbers by police forces. And she suggested that her office be notified after an emergency disclosure demand is made, not as an approval mechanism, but just simply to monitor the use of emergency demands, presumably in terms of frequency, in terms of situation, perhaps in terms of scope, and to evaluate over time whether they're being undertaken in an effective manner that's proportional to the privacy impacts on the individual whose records are disclosed, in her own words. I believe that if the Privacy Commissioner had concerns, she would likely raise them first with the Justice Minister. In fact, I'm quite certain about that. And it would only be if those concerns were not addressed that she might then actually raise them with members of the legislature, and through the legislature, of course, to the public. So it seems to me to be a reasonable proposed amendment, one that would give the public some sense of security that somebody was looking at the use of these demands when they are not being made through the judiciary. as she has said, the notification could occur when the member files the written report with the officer in charge. That's already required by Section 13.2. It would simply be, I guess, another copy. So it would be a fairly simple amendment. She suggests requiring the officer in charge forward a copy of the written report to her office. She draws a similarity to that contained in Section 25 of the Freedom of Information and Protection of Privacy Act. In that case, her office is simply advised by the police force that it has issued a notice that a dangerous offender has been released from prison, and the reason that the notification is in the public interest. That seems like a reasonable proposal from the Privacy Commissioner. I would hope that the Minister of Justice is seriously considering such an amendment. It would seem, in my view and those of my colleagues on this side of the House, to be respectful of the concerns and the integrity of the protection of privacy for which the Commissioner is responsible, does not in any way that we can see interfere with the administration of the bill or with the ability of police to make an emergency demand for disclosure and subsequently to protect, if it is still possible to protect somebody who is missing, or simply find them before they do some harm to themselves or they come to some harm. So I would be interested in hearing from the Justice Minister and request from her through you whether she has given some consideration to this proposal from the Privacy Commissioner or some other mechanism, although it's hard to imagine a simpler one than this, that would allow some form of oversight of the use of emergency demands that do not require judicial approval.
Member for Burnley Edmonds has circulated amendment. Is this proposed amendment is officially tabled, or?
I'm absolutely happy to move that amendment at any point. If the minister wants to answer the question first, that would be fine, and then I'll move the amendment.
Thank you. Minister.
Chair, the Section 18 refers to an annual report made by police forces respecting emergency demands for records made by that police force, and they must provide that police force to myself, and I must make that annual report public. And that will be a comprehensive reporting, Chair, of all of these kinds of orders which are made during the course of a year. And it is our belief that that is sufficient in terms of monitoring the application of the Missing Persons Act and the emergency demands for records under the Missing Persons Act.
Member for Burnwood Deer Lake.
Thank you, Honorable Chair, and through you, and I would like to propose an amendment to Section 13 of the Act. It's an addition, and I'm not going to read the whole section because it's very long, but the proposal is that after sub 13 subsection 2, that a clause be added that reads, "The officer in charge must forward a copy of the written report to the Office of the Information and Privacy Commissioner." And I believe, and I move that amendment, and I believe you have copies of that.
Thank you, member. Any discussion on the amendment? Member for Vancouver Fairview.
Thank you, Chair. I rise in support of the amendment. I note the answer of the Justice Minister to my previous question, and with respect, I think there is both a quantitative and a qualitative difference in the provisions of Section 18 to what is proposed in an amendment for Section 13. First of all, a year is a long time. It makes sense when we're dealing with something as fundamental and critically valued by British Columbians as their right to privacy, a value that's enshrined in British Columbia law, in Canadian law, in laws in virtually every democratic country around the globe, and a right that is highly, highly prized by individuals. To know that there is some oversight that takes place on more than an annual basis about the extent to which that right is being respected in emergency situations, and we've already admitted that missing persons are an emergency situation, or whether that right is being infringed upon in an unnecessary or perhaps inappropriate way. If we accept the argument that a review once a year is sufficient, that doesn't quite square up with the requirement in non-emergency demands for disclosure for judicial oversight and judicial approval. On a qualitative basis, with the utmost respect to the Justice Minister, it makes more sense that the person, the Commissioner, the independent officer of the legislature, who is charged with protecting the privacy of British Columbians, whose office is established to protect and advise on the privacy, the personal privacy of British Columbians, be in a position to monitor on an ongoing basis, particularly in the early stages of the implementation of a new act like this that has the potential. I mean, it does infringe on the privacy of individuals. The question simply is, when is such a infringement on the privacy of individuals justified, and when is it not? So it would allow the Commissioner on an ongoing basis to monitor the usage of emergency demands, to communicate to the Justice Minister, and if necessary to legislators in this House about whether the use is proceeding as envisioned and as appropriate and in a way that is properly balanced with the privacy rights of British Columbians. So with respect to the Justice Minister, I think the amendment proposes what Section 8 does not, and that is that there would be an ongoing monitoring of the use and not simply cumulative assessment at the end of every year, which allows possible abuses which could be mounting up to be addressed in a hopefully collegial way through a discussion with the Justice Minister at an early stage, and it also allows that monitoring to take place by someone who is an independent officer of the legislature charged with protecting the personal privacy of British Columbians, not by the cabinet minister who is responsible for introducing the bill in the first place. I understand that the report will be made public. I understand that the Privacy Commissioner would be able to comment on the contents of the report on an annual basis, but frankly, Honourable Speaker, I don't think that is good enough. I don't think that meets the the sense of security that British Columbians would like to see applied to disclosure of a whole range of their personal information, particularly with respect to some issues I raised this morning about the scope of a request for disclosure. The answer in the case of an application to a justice is that the justice is empowered to limit the scope of disclosure of, say, texting records or internet browsing history or cell phone records to the case at hand. In the case of an emergency demand for disclosure, it's not at all apparent to me, or I suspect anyone else, just exactly how that limitation will take place, and to wait a year for assurances that that it won't be inappropriate seems to me to be too much. It certainly seems to the Commissioner for Privacy to be too much. It appears to the association, the Freedom of Information Protection of Privacy Association and the BC Civil Liberties Association, all of whom work on a daily basis to protect the human rights of British Columbians, the privacy rights of British Columbians, and the rights to information of British Columbians. It does not appear to them to be sufficient. I would simply submit in support of this amendment and in requesting that the Justice Minister take a hard second look at the content of our amendment and how it differs from Section 18, and to members opposite, how it differs from Section 18, to take the recommendation of the Privacy Commissioner not as a challenge to authority, but as a legitimate safeguard of the rights of British Columbians that in no way whatsoever intrudes on the application and implementation of this important power that is given to police to gather private information to further the finding of a missing person who may be at risk. It does not interfere in any way whatsoever with that primary function of the Act, and as such should be an amendment that the government is willing to entertain. Thank you.
Member for Vancouver Fairview.
Chair, I appreciate the Minister essentially repeating the same answer that she gave earlier to my question, but I did understand her answer the first time, and I would submit that we're in a fairly significant disagreement here. The Minister believes that the oversight of the officer in charge in an annual report is a proper substitute for the very serious concerns that were raised by the Privacy Commissioner, an independent officer of the legislature who specializes in protecting one of the most fundamental rights of British Columbians. But even if there was no resolving that disagreement between myself, my colleagues, and the Justice Minister and the Justice Minister's staff, what the Justice Minister has failed to answer in any meaningful way is what possible harm could come to the administration of the purposes of this bill by accepting a recommendation for amendment by an independent officer of the legislature who is thoughtful, well-regarded nationally, and an expert in the protection of privacy. What possible damage to the ability of the police to find and protect missing persons would be done by accepting this amendment? She has not spoken to that at all. It seems to me that in the interests of British Columbians, in the interests of assuring British Columbians that this government has the highest regard for the sanctity of their personal private information and will only allow it to be breached in emergent situations, this government would want to, and this minister would want to, take the extra step. And the extra step in this case is heeding the advice of an expert independent officer of the legislature. I understand why the minister and the government don't want to accept an amendment put forward by the opposition, although I do consider it a sign of an unreasonably stubborn attitude to what should be collegial discussions in this House about making legislation the best it can possibly be. But I simply do not understand why that stubbornness would extend to a suggestion from a highly regarded independent officer of the legislature whose job it is to protect before the fact as often as possible and to the greatest extent possible the sanctity of people's private information a sanctity highly valued by British Columbians, a sanctity that's considered a human right and should only be breached in the most emergent of situations, and to allow an independent officer some level of after-the-fact oversight of the application of this bill seems to me to be entirely appropriate. What is inappropriate is the inability of this Justice Minister to separate herself from the bill that she has taken responsibility for and allow it to be improved, or at the very least, allow it to be seen by British Columbians to be a bill that includes every possible safeguard of their private information. And for that reason, I will be supporting the amendment, and for that reason, I and my colleagues will be voting for it. Thank you. Thank you, Chair. I appreciate the comment of the member from Burnaby-Deer Lake that we want to get through the rest of the bill, so I'll make my comments quite brief. This is a rather large hole through which people can move. If the purpose of the bill is to locate a missing person, it's difficult to imagine what more is needed. And without clearly understanding what a purpose consistent with the act is, or pardon me for a moment. Sorry, not consistent with the act, but consistent with the purpose, which is much different. It just seems unnecessary, but it also seems potentially dangerous, as pointed out by the Privacy Commissioner. I support the amendment. I don't think it's necessary. I think it's vague. It's non-specific, particularly if it's used in an emergency situation without judicial oversight. I do not see the need. I do see the danger, and I think that the amendment that that is being proposed by the member for Burnaby-Deer Lake and was also proposed by the Privacy Commissioner should be heeded.
Minister.
Set out in section 20 where a similar amendment was considered, I will not be supporting the amendment.